Okay, welcome everybody. This morning we are going to talk about family and medical leave. This is one of those legislative acts that's been around for a long time. I believe it went into effect way back in 1993, and it continues to be one of the most misunderstood laws out there. I continue to get a lot of questions as an HR consultant from clients about it, particularly from those who are new to HR and haven't been dealing with it all these years like I have. So feel free. I'm going to make this an interactive discussion. Usually Anita Prouty, who is one of my coworkers at NFP, is on here and monitoring the chat. Unfortunately, she's a little under the weather today, so she is not going to be doing that. I'm going to do my best to monitor the chat, but I would really encourage you to actually unmute yourself with questions. So again, we can make it interactive. And that way too, I am not looking like I have to be monitoring that while I'm also trying to speak. So, and I'm just taking a look because I already have a couple of messages. Yes, the slides will be emailed going forward, and as well as a link to the recording. So if you have any coworkers out there that you'd like to share this with, by all means do so after this presentation. I really encourage you to do that. This is my consistent legal disclaimer. I'm not an employment attorney, and the purpose of today's session isn't to be necessarily answering individual questions. And very often these things get tricky enough that you should probably be seeking legal counsel if there's a particularly tricky situation. And I also like to make anyone aware who might be listening to this recording at a future date that things do change. Although FMLA has been fairly consistent, I can't guarantee the accuracy of the content if you're looking at this at a later date. So what we're going to go over today, we are going to talk about FMLA, and that is short for Family and Medical Leave Act. That's the federal legislation. We're also going to talk about Vermont's version of FMLA, which is what we call VPFL. So stick those acronyms in your mind because that's the terminology I'm going to be using today. It's a lot easier than spelling it all out. I'm going to talk about how they interact with other leaves, because this is where it gets confusing for a lot of people, particularly those of you who are kind of new to the HR world. And we're also going to be talking about what you need to do to actually administer FMLA. And then we're also going to touch a little bit on Americans with Disabilities Act, or ADA, considerations, because that does come into play when you're talking about medical leaves. And I want to start off by saying today we're going to be talking about the federal legislation as well as Vermont legislation. But if you are a multi-state employer, the state in which your employees work is the leave law that's going to govern that particular employee. So say, for example, you have one employee who works in California. You're going to have to familiarize yourself with the California leave laws because they can be a little bit tricky. New York is the same way. Washington has a leave law. So if you have employees, even if it's only one employee working in other states, you're going to need to familiarize yourself with the leave laws in those particular states. And if you need some help with that, all of you should have access to an HR database called Xywave. And if you don't, let me know, let your account executive know. We will get you access, but all of you would have gotten an invitation to set up a portal so that you have access to this database at one point in time. So if you don't have it, let me know, let your account exec know. We will get you up on that. But that has a whole section state by state on leave laws in each individual state. But for the purposes of today, we're going to be talking about the federal one, and we're going to be talking about the Vermont leave law.
Susan,
Yeah?
would that include employees working remote?
Yes, it would. So all it takes is one employee working remotely in another state, and you need to be looking into what the leave laws are in that particular state.
Thank you.
You're welcome. See, it makes your life more complicated. COVID is a wonderful thing. We can hire remote employees, but it does make the HR role more extensive. So what we're going to talk about today, we're going to talk about the minimum statutory requirements. In other words, the basic minimum of what these laws say that you as an employer need to do. But I want to make you aware that you can always be more generous than what the law says you have to do. So a good example of this is that FMLA is unpaid leave, and it's for giving birth or becoming a new parent. You may, as an employer, have your own parental leave that pays employees for parental leave. That's fine, because you can always give more than what the law says that you need to give. But what we're going to be concerned with today is just that basic minimum of what you need to do. So let's start digging in a little bit to what who has to follow FMLA versus who has to follow the state law. So FMLA is applicable if you have 50 or more employees and you're a private employer. If you're a public agency, for example, a public school, regardless of the size, you have to be offering FMLA. And the basic tenet of FMLA is that employees get up to 12 work weeks of unpaid job protected leave in a 12-month period. Now, in Vermont, it's very similar to FMLA. What the state of Vermont did is shortly after FMLA went into effect, they said, well, that's great, but we have so many small employers here in Vermont that we want to have a similar leave law that's going to reach a broader scope of employees. So we want to make this applicable to employers who have 10 or more employees for the parental leave portion of it, or 15 or more employees for the family leave portion of it. And the family leave is going to apply for the employee's own illness or that of a family member. I have no idea why there are two different thresholds, but there are. And what a lot of employers I've seen here in Vermont do is if they have 10 employees, they just make, they will follow the terms of VPFLA for both the parental leave and the family leave. But just bear in mind that there are two different thresholds for that. The Vermont leave also has a short-term family leave provision, and that allows for up to 4 hours of what they call short-term family leave in any 30-day period, and it's capped out over the course of a year to 24 hours. And that leave is available, again, unpaid, for employees to go to parent-teacher conferences, to take children to doctor's appointments, to take parents or parent-in-laws to routine medical appointments. I think most employers are flexible enough that they just will give the employees time off for these things. But bear in mind that if you have an employee that comes and says, I need to leave work early today because I need to take my mother to a doctor's appointment, you can't say, no, sorry, you can't go, because they are entitled to that time off. So bear that in mind. A really good summary of the provisions is going to be in the employment poster that you should have in your workplace for VPFLA. That gives a really good summary of what the provisions are. So if you have 50 or more employees, you are required to follow both the state and the federal. And they run together. So they're not stacked. It's not like the employee gets 12 weeks of unpaid leave for FMLA, and then they get another 12 weeks under the state provision. They run at the same time. But the laws have a few nuanced differences. So what you need to do if you've got an employee who is qualifying for leave is to take a look at both statutes and determine which one is going to be the most beneficial to the employee. And that's the provision of the law that you're going to need to follow. Now, if you're on that threshold of, I'm not really sure whether or not we need to be following FMLA or whether we need to be following VPFLA, this is how you calculate the number of employees. FMLA says 50 or more employees in 20 or more work weeks in the current or previous calendar year. So if you are near that threshold, that's how you do the calculation. Again, what a lot of employers do is if they know they're hovering around that 50, they say, you know what, we're just going to follow FMLA. It's probably easier than doing the calculations and wondering where you are. If you're close to the threshold, you might want to do that because you're already offering VPFLA. It's not going to be a whole lot different. So for VPFLA, that 10 or 15 employee threshold is determined by employees working an average of 30 hours per week over the course of a year. So again, employers who are near that threshold, very often what they say is, we're just going to follow it no matter what, because I know that we're close. And following those provisions keeps you competitive in the marketplace, because if you're competing against employers who are meeting that threshold and their employees are going to be entitled to leave, but you're not providing leave to your employees, well, that's just one less of a competitive advantage that you've got there. And we all know that in this job market, that's kind of important. So I'm going to take some time to actually go over what FMLA can be taken for and what VPFLA can be taken for. So FMLA, let's start with that. We've got the birth of a child or the placement of a child with you for adoption or foster care. Your own serious health condition. So that means somebody is having surgery. They're undergoing some sort of health treatment. To care for a spouse, child, or parent due to his or her own serious health condition. So bear in mind that under the Vermont statute, parent-in-law is included. So again, this is an example of if you've got somebody who qualifies for FMLA, you need to take a look at both statutes and then determine which one is the broadest and which one is going to provide that leave for your employee. So if you've got somebody who comes and says, I'm going to be taking my mother-in-law to chemo treatments, so I'm going to be needing some time off for that. If you're just looking at the FMLA provision, you're going to say, well, that doesn't qualify. You need to take a look at the VPFLA piece as well. A qualifying exigency, and this is a military type leave. So if you've got a family member who is being deployed, very often there are activities that families participate in, that falls under FMLA. You are also eligible for FMLA to care for a spouse, a parent, son, or daughter, or a next of kin who's a covered service member and who needs your care due to a serious illness or injury. Okay. The law says that you have to, at the end of that 12 weeks, and it's 12 weeks total. It's not necessarily just one chunk of 12-week time. And we're going to get into intermittent leave in a couple of minutes. You have to restore that person to a comparable position. By comparable position, it means same level of pay, same benefits, same level of responsibility. If you have multiple people doing the same job, you don't necessarily have to hold that job. If you can find somebody to replace them while they're out, that's fine. But just bear in mind that when they come back after that 12 weeks, you have to put them back into that comparable position, even if it means that you're going to be overstaffed. You have to continue their group health benefits while they're out as if they never left. So everything has to continue. However, if the employee is paying into their health benefits, so if normally there's some sort of a payroll deduction, bear in mind this is going to be unpaid leave. So you can still collect that premium from the employee. And what most employers do is they ask, you can do it a couple of different ways. You can ask the employee to send you a check while they're out for your monthly premium. You can front load it if they have some notice that they're going to go out. You can double up on premiums before they go out that will cover them during the leave. What I don't recommend that you do is say, well, when you're ready to come back, we'll just collect the premiums out of your first paycheck. The reason behind that is, what if the employee doesn't come back from FMLA? Then you really have no way to be collecting the premiums from them. So I would suggest either front loading it or asking them to write a check while they're out. A question always comes up about, do they accrue PTO time while they're out on leave? And the answer to that is, it depends. You take a look at your own policies. If the leave is unpaid and they're not eligible for any other pay from you, like sick time or vacation time or PTO time while they're out, then you would not have to accrue PTO time for them. If, however, while they're out, they're going to be paid out for some of their sick time or their PTO time, then you have to follow whatever your company policy is for an active employee who's out taking vacation or sick time. Most employers continue to accrue PTO time while an employee is out on their own vacation time. And if that's the case, if you have an employee who's on FMLA and you're paying them their PTO while they're on FMLA, then they would need to continue to accrue the time while they're on FMLA as well. So, rule of thumb, treat the employee as if they're an active employee. If you're paying them wages, they're accruing PTO time. If you're not paying them wages, then you don't have to accrue PTO time. And there's also a retaliation piece to FMLA that says that you can't retaliate against an employee for taking FMLA. And, I don't think most employers are going to overtly retaliate, but where you need to be careful is, say, for example, you have an employee who wants to attend a conference and they're going to be out for a week and they've just come back from FMLA, and you've got a manager saying, well, I can't lose them for another week. I've just had them out for 12 weeks. I'm not going to let them go to the conference. That could potentially be considered retaliation. So in other words, you're treating that employee differently because they invoked their right to FMLA. So those are the little things you have to be on the lookout for. Now, the Vermont leave does not include the qualifying exigency or the leave for placement of children for foster care. But again, remember, you can always be more generous than the law says. So in other words, if you fall under VPFLA, but you don't have that 50 employees, you don't have to offer the qualifying exigency. You also don't have to offer leave for parents who are taking a child in for foster care. But VPFLA does include that short-term family leave provision, that parent-in-law leave, and one of the other kind of nuanced differences is that under FMLA, the employer can require the employee to take accrued sick time or accrued PTO while they are out on leave. Vermont says, no, you can't do that. You have to give the employee a choice whether they want to take their paid leave while they're out on unpaid leave. So bear that in mind. It's another one of those situations where you can't just look at the FMLA provisions. You have to consider it as a whole. Do we have any questions so far? Okay, I will keep moving forward. As far as who is eligible, with FMLA, if you have an employee who has 12 months of service and 1,250 hours in a 12-month period, they're going to be eligible. They also need to be working at a location where you have 50 or more employees within 75 miles. So, for example, if you have a remote employee working in a different state and you have over 50 employees, so you have to offer FMLA, that person isn't likely to be working within 75 miles of 50 employees. So technically you don't have to offer them FMLA, but again, I think most employers are doing it. That provision is in there for employers who maybe have a very large facility at one end of the state and a smaller facility somewhere else in the state. The small facility really can't go without without one of its important employees for 12 months. So it's able to say, no, we can't give you that time off. But I think in reality, most employers are giving it anyway. Vermont's criteria is a little bit different. It's actually a little bit of a higher threshold. 12 months of service is the same. the employee, in order to qualify, has to work an average of 30 or more hours per week over the past 12 months. So that threshold is a little higher. Instead of 1,250 hours, it comes out to be 1,560 hours. And Vermont one does not have that location provision in there. It's just based on total employee headcount, regardless of where they work. So in determining the hours worked, it's really easy if you've got a full-time employee, because if they're full-time working approximately 40 hours a week, 52 weeks a year, they're going to be well over the threshold. Your part-time employees, you're actually going to need to take the time to go back and calculate, particularly if somewhat variable hour employees. So the Vermont law requires you to include sick and vacation time in hours worked. Any time that anybody may have been out on military leave has to count as hours worked. So just bear in mind, you're not just looking at hours that they have submitted on a time card and actually physically been in the workplace. You have to take into account their paid time off as well. And you should keep a record of the hours calculation along with the FMLA forms. And the retention requirement on that is 3 years. So even if you calculated hours and an employee does not qualify for FMLA, you should keep that record of that hours calculation with the FMLA request or with any documentation that the employee has actually qualified for FMLA due to their circumstances, but they didn't qualify due to their hours. Should keep a record of that just in case it ever gets questioned. This is my go-to document. I strongly suggest that you bookmark it. It's put out by the Vermont Commission on Women. It's a really good document that offers a side-by-side comparison of FMLA and the Vermont statute. So it's a really good document. If you've got somebody who is experiencing a potential FMLA qualifying event, you can go to this document and take a look at the examples, take a look at the situations, and it helps you to do that side-by-side comparison of, okay, does this person qualify? Do they not qualify? What do they qualify for? So let's dig into intermittent leave. It's really easy when an employee comes to you and says, I'm going to have surgery. I need 6 weeks off. It's usually pretty cut and dry. You get medical documentation, piece of cake. Where it gets tricky is when you have what's called an intermittent leave. So somebody's going to be using up that time, but it's not a consecutive days in a 12-week period. It's going to be spread out. A good example of this is somebody who is missing time due to, say, cancer treatments. They have to go and get chemo or they need to get radiation. So maybe they're going to be missing 1 or 2 days a week every couple of weeks. That you're going to have to keep track of as FMLA time in your payroll system. Most payroll systems, you can designate hours to, regular wages. You can designate them to FMLA hours. If you don't have something like that set up in your payroll system, I'd strongly suggest that you do that, because it's always much easier to have somebody tracking it in a payroll system than to be putting it out there on a spreadsheet somewhere. But it is up to you as an employer to actually track the time that an employee is out for intermittent FMLA leave so that you can keep track of the time that they have off. So intermittent leave is only for medical necessity. And I mention that because you may have someone who, say, for example, it's a new father, and this new father comes to you and says, I've just had this baby and I don't want to take 12 full weeks off. I want to be able to work 3 days a week and take 2 days a week off until I use up my 12 weeks. If you want to do that, that's fine. But assuming that the baby is healthy, there's no medical necessity there. That's a pure parental leave. If, on the other hand, the baby has some sort of a medical issue that requires the parent to take the child for medical treatments on an intermittent basis, that's different. But assuming it's a healthy baby, you don't have to offer it on an intermittent basis. You may want to. It may make more sense for you as an employer to have your employee there 3 days a week as opposed to having them out for 12 straight weeks and not having them there at all. Totally up to you. But just bear in mind, if there's no medical necessity, you don't have to accommodate that. What you can do is you can require your employee to give you as much advance notice as possible. Sometimes they can do that, sometimes they can't. Sometimes these are emergency health issues. There's nothing that you can do about that. But you can, if they know in advance that they're going to need the time off, you can require them to give you as much notice as possible. And you can also require them on an intermittent basis to follow the appropriate call-in procedures. And I will give you an example of this. If you have someone who is out on who has an approved FMLA leave for migraine headaches, and this is one of those tricky situations because you might have medical documentation that says, well, if they wake up with a migraine, they're not going to be able to come to work. That doesn't mean that the employee doesn't still have to call in the morning and let somebody know that they're not going to be there that day. It doesn't give them carte blanche to just be taking time off and not letting anybody know about it and just disappearing. Again, absent any unusual circumstances, and that's all going to be taken on a case-by-case basis. So just make sure that you're clear if somebody's on intermittent leave and it's not a set schedule, that they still need to follow whatever call-in procedures that you have in place. Recertification can get a little bit tricky because sometimes these leaves, if they're not using up their full 12 weeks in a 12-month period, you can ask them to recertify it every year or anytime that the reason for the leave changes. So if you have somebody who's out intermittently with migraines, and then all of a sudden they're going to need to be out for a different FMLA reason, well, that's going to be a different reason that's going to need additional documentation. Or if you've got the pattern of absences, the frequency changing. I'll go back to the migraine headache example because I've seen this come up multiple times. You've got doctors' documentation saying this person might need to be out 2 to 3 times a month. And suddenly you've got this person out 1 day a week, 2 days a week. And instead of a couple times a month, it's turning out to be 1 or 2 days a week. That's a change. You can go back to that employee and say, you know what, this is outside of the scope of what your doctor said you're going to need to be out for. So we're going to need you to go back to your medical provider and get that changed. If this is new and you're going to be out more frequently, we need to see some sort of medical documentation that that's going to be the case going forward. I've seen more circumstances in the last year of people taking FMLA for mental health reasons. And when you think about it, a mental health condition is generally treated like a serious health condition. And that means that it does generally qualify for FMLA. And it can get really tricky because mental health is a very unpredictable illness. And it's really hard to pin down. It's very simple. If you've got somebody who's going to be, say, in an inpatient facility being treated for X number of weeks, that's pretty cut and dry. But very often mental health conditions warrant this intermittent leave, and it can get really, really hard. It's hard on the employer. It's hard on the employee. The Department of Labor, just in the past couple of weeks, has actually come up with a fact sheet. So I give you the link to that. You'll want to take a look at it if you have an employee who is experiencing absence due to mental health conditions, because again, that will likely qualify as FMLA. So you should be thinking along those lines. Review the fact sheet, review the FAQ. And NFP just last week actually did a podcast on this. It's only 15 or 20 minutes long. If you've got a situation that could potentially qualify for FMLA due to a mental health condition, I'd strongly recommend that you listen to the podcast as well. It's a good one. It's pretty informative. But just remember, if you've got somebody who's missing time from work and it's due to mental health reasons, that will likely qualify as FMLA. As far as requesting FMLA, there should be something in your handbook that talks about what FMLA is, what Vermont Parental and Family Leave is, and here is what you need to do and who you need to notify if you're experiencing a qualifying event. But just bear in mind that according to the law, the employee doesn't need to actually come out and ask for FMLA. The employer only needs to be aware of a circumstance that could potentially qualify. And the rationale for this is that employees aren't necessarily going to know that FMLA exists and that they have rights under FMLA. So you can't assume that they have enough knowledge to actually come to you and ask for it. So you as an employer need to be aware. And this is where it gets really beneficial to make sure that your managers, your frontline people who are out there dealing with their employees on a day-to-day basis, are at least aware of what these FMLA qualifying events are. So that if they have an employee come to them and say, you know what, my spouse is going to be undergoing some cancer treatments, I'm going to need some time off, but I'm just going to take my vacation time. That manager should have enough knowledge to say, this could potentially qualify for family and medical leave. Go talk to human resources or go talk to whomever in your organization does HR. So it's really important to get the word out there to the frontline people who are dealing with your employee of what would potentially qualify as family and medical leave. Any questions? Feel free to unmute. Okay, I will keep moving forward then. So for FMLA, the Department of Labor provides forms. And here's the link to the forms. And I always suggest that you use these forms because they cover all of your bases. They talk about what the employee rights are. I'm not going to get into the form for the sake of time, but I would suggest that you go and you take a look at them. They're really self-explanatory. They have check boxes. You just go down the list and you check off boxes as you go and you hand over the and say, here you go, you do qualify, you don't qualify. This is what we need from you. There are medical certification forms out there for the employee's own illness. There are standard medical certification forms for a family member's illness that the employee would have to bring to the medical provider and then send back to you. So they're very self-explanatory. So that's great if you're over 50 employees. If you're not, and you just have to follow the state statute, Vermont doesn't provide you with model forms. So I would just caution against using the federal forms if you don't fall under federal FMLA. So again, if you're below 50 employees, because those forms reference the federal FMLA statute all the way through them, and it can get really confusing for the employee. So what I would do is just make your own forms. Take a look at the federal forms because they'll be a good guideline for you, and make your own form as opposed to if you have an employee who is experiencing an event, just trying to put it all into a letter because you're probably going to miss pieces. You can put it into a letter, but I would go ahead and have a template put together and ready to go, so that you're not at the last minute trying to figure out, gee, if I covered all my bases, if I told them everything that they need to know, have I told them how they're going to pay for their medical expenses, for their medical premiums while they're out and not getting a paycheck. There's a lot of little pieces that you should be informing them about. I also suggest that when you have an employee who qualifies under the Vermont leave, that you send them a copy of the Vermont employment poster, because that says it all. That gives them all their rights. And it's actually a very informative poster. So just a note though, if you are over 50 employees and you're using the federal forms, that there's one checkbox in particular that does not apply in Vermont, and it has to do with that time off. That form will say, it'll give you a couple of choices. One of the choices is we're requiring you to use your accrued paid time off. Don't ever check that box because, as I said before, Vermont does not allow that. Vermont gives the employee the choice of whether or not they want to use that time off. But the forms get into as much detail as you have X number of hours of paid time off available to you. And then the employee has to come back to you and say, yes, I want to use that time off, or no, I don't want to use that time off while I'm out. This is a helpful flow chart. I put it together for FMLA, but you can follow it for the state one as well. It's just that you're going to be using your own forms as opposed to the state forms. So just to take a quick minute and go over this, it starts with you've become aware of an employee who has a potential qualifying situation. So if they are eligible, you have 5 days to send out the what's called WH-381 form, and that you can find in that link that I provided a couple of slides ago. And that form is going to notify the employee that, yes, you are eligible, and this is the next step. This is what you need to do. This is the certification that you need to get back to us. Or it's going to say, no, you're not eligible, and here's why. Will allow you to check off the box for the reason why they're not eligible. Maybe they don't meet the hours requirement. Maybe they haven't been there for 12 months. If they don't qualify, that's it. It ends. But then you're probably going to be talking to the employee about what kind of an accommodation you might be able to make for them anyway. But you're at least following the letter of the law and letting them know that they don't qualify for FMLA. If they do qualify, they have 15 days to get that medical certification back to you. That doesn't mean that you automatically reject them at the end of 15 days. But that's technically the threshold that there is, but I wouldn't recommend if somebody hasn't had their physician fill out those forms yet. I bend a little bit on that because sometimes doctors' offices can be a little slow, forms get lost. Bear in mind that when an employee is in a situation like this, very often it's a difficult medical situation. So it may have come out of the blue. It may be something that they haven't planned for. And there's a lot of other things going on in the employee's life at this point. So, just bear in mind that there should be some built-in flexibility there, but you can let the employee know if it gets to be 15 days and they say, oh, I just keep forgetting, that's not an excuse. You can tell them you really need to get that back to us. And then you as an employer have a 5-day turnaround to let them know that, yep, we've got everything in place. Your leave has been approved, or no, it hasn't been approved, and here's why. And then my recommendation when an employee is out, that you check in with them from time to time. Again, depending how long they're going to be at, depending on what the situation is, it's a good idea to check in with them from time to time, see how they're doing, especially if it was kind of open-ended and you're not really sure when they're going to be back. And you can certainly ask them to be following up with you periodically as well. And that's part of the certification form. There's a blank spot that says, we expect you to be following in with us every week or every 2 weeks to let us know what your situation is, so that the employee isn't just hanging out there for 12 weeks without any communication. Now, there are other leaves that are also for FMLA qualifying reasons. So there's overlap going on here. So you might have an employee who has a lot of accrued sick time, particularly in nonprofits. We see this a lot where employees are accruing time year over year, and they might have a month of accumulated sick time. And you might have an employee saying, I need to take 3 weeks off. I'm having some minor surgery. I'm just going to take my sick time. That's still an FMLA situation. So bear in mind that that should trigger the FMLA forms, and you should be designating that time as FMLA time, as opposed to, well, they're just using their sick time. And here's the reason for that. If you don't designate it up front, it gets really fuzzy with how far back can you go and designate it as FMLA. So you might have an employee who thinks this is really just a minor situation. I'm only going to be out for 3 weeks. 3 weeks turns into 4 weeks, 4 turns into 6 weeks, 6 weeks turns into 8 weeks, and suddenly you don't know when this employee is going to come back. If you've never designated it as FMLA time, then it gets really hard to go back and designate it retroactively. And all of a sudden you're looking at this employee's been out for close to 12 weeks. I never designated it as FMLA time. Now I have to do that. And they get an additional 12 weeks starting from when you designated it. So it's just really important that even if it seems to be a minor situation, the employee is only going to be out for a couple of weeks, designate it as FMLA time because it does run together. The same thing with short-term disability. Some states have mandatory short-term disability. Vermont does not. Or maybe you have a short-term disability plan through NFP. And you've got the standard, for example, and you've got an employee who applies for short-term disability. You should also be designating that short-term disability time as FMLA. Again, they run together. Workers' comp, the same thing. This one gets missed a lot. So if you have an employee who is missing time due to a workers' comp injury, and their salary is going to be paid by the workers' comp provider, it's still family and medical leave because the absence is for the employee's own illness or injury. So it should be designated as FMLA time as well. And parental leave is the same thing, that if you've got your own parental leave policy, or you've got an employee who's working in a state where they have a parental leave law, that should also be designated as FMLA. I will let you know that there are some situations where a state's parental leave law could be stacked with FMLA, so it could entitle an employee to more than 12 weeks. I'm going to be sending as a handout. NFP has a white paper. It's like a chart that has different states and a summary of what their leave laws are. So when I send out the link to the recording and I send out a copy of the slides, I'm also going to be sending that out so that you have it and you can take a look if you have employees in other states. So if you're kind of trying to wrap your arms around how this works, I tried to put a graphic together that might help to explain it. Just remember that first and foremost, you should be thinking of your FMLA and your VPFLA, and that is unpaid leave. All of these other leaves, your sick time, vacation, paid parental leave under your company policy, your company disability plan, are ways for your employees to be paid during that unpaid leave of absence. So always be thinking FMLA first, and then think, okay, so what mechanisms do we have in place that might provide some payment for that employee while they're out on their FMLA? Any questions?
Hey, Susan, it's Ellen Liptak. I've got a question that I have an employee who needs 2 FMLA leaves, and I'm assuming that they run concurrently, so he's only entitled to 12 weeks. Is that correct?
Yes, it's 12 weeks total. And that's a really good point, Ellen, that you can have employees who experience more than one qualifying event in a 12-month period. It's not 12 weeks per event, it's 12 weeks total.
Okay, great. Thank you.
You're welcome. Really good point.
Susan, this is Laura. I have a question for you. So if there's an employee that becomes injured while performing their job, it became a workers' comp issue, and this has been happening or ongoing for the past 2 years. They're not under workers' comp anymore, but we got to a point where he was not able to perform his job duties. So there was a talk of, a termination letter, as we could not accommodate what he needed, given his injuries. So how will the FMLA start with this? Meaning, before terming the employee, do we need to give them this option of using FMLA? So he's still working. He works maybe 40 hours every 2 weeks, so 20 hours per week. But the other 20 hours, the employee complements with either sick time, vacation time, holiday, to just make up for the full paycheck. How does this work?
Yeah, this is kind of a loaded question because I don't really have enough info on all of that and on the history of that. My first question is, has any of this time ever been designated as family and medical leave time?
No.
Okay. And this gets a little bit loaded, and anytime you're talking about workers' comp and you're talking about, are you talking potentially terminating the employee?
Yes.
Okay, this gets into a legal realm, and I would suggest that you go over this situation with legal counsel because it does get, it's not cut and dry.
Okay.
And they're going to be best able to tell you, to listen to the whole situation and tell you what your risks are.
Okay. Thank you.
You're welcome. Any other questions?
Hi, this is Sherry.
Hi.
I was curious, when you say remote, if the person lives in another state, like New York, let's just say New York, but she may, they just happen to work there sometime, is that not really remote because that person could come to Vermont, to the office, but chooses to stay home sometimes and work from home?
It go by whatever state you're paying the unemployment taxes to.
Okay.
So whatever state that person is registered as working in is the state laws that you would follow.
Okay, thank you.
Okay, you're welcome. Other questions? These are good questions. Any others? Okay, we will move on. Americans with Disabilities Act, or ADA, does come into play during this because if you think about it, if it's an employee's illness and it's going to be over and done in a couple of weeks, that's not considered a disability. But if you look at the definition of what a disability is, it's a medical condition that would limit a major life function. So something that would qualify as FMLA, for example, a mental health condition, would probably also be considered a disability. And there are some protections that need to be offered under the ADA. The ADA requires that employers make reasonable accommodations for employees who have disabilities. So one of the potential accommodations could be unpaid leave. So it gets really tricky. But where it would really come into play is if you've got an employee who has used up their 12 weeks of time and they're not quite ready to come back. Instead of just saying your 12 weeks is over, now we're terminating employment, you should always take a look at it from an ADA perspective and say, wow, this person's been out 12 weeks. That's a long time. Whatever this person has may very well now be considered a disability. Cancer could be considered a disability. And then you need to take a look at, do we need to be making a reasonable accommodation to get this person back to work? Or should we be offering additional leave over and beyond the 12 weeks as a reasonable accommodation to this person? And my advice to you on this would be, if you've got a situation like this where they've been out for 12 weeks, they're not ready to come back, that's when you should likely be able to walk through it with you, let you know what your risks are. They're going to know all of the recent court cases that might have gone one way or another that might help you to determine what's the best way to go with this. So again, if you have this situation come up, that's when it's time to talk to your attorney. Record keeping. What I would recommend to you is that any information that you have on an individual's FMLA, you keep it together in their own FMLA file, but don't put it in the employee file because that file is likely going to have personal health information. It's going to have information that wouldn't potentially be used to make an employment decision. So it should be kept totally separate from the employment file. And the retention requirement on that is 3 years. So if you're doing paper files, in a totally different file cabinet, not just a folder within the employee file, take it out of that, put it in a totally separate location. If you're doing it electronically, just make sure again that it's not in the same electronic file, and keep it either password protected or in some sort of a folder that has very limited access. Only people who would need to know, such as you in HR or a payroll person, are the only ones that should have access to that. And again, 3 years is your retention requirement on that one. Your best practices for getting the information out there to your employees, and also for meeting the requirements for dissemination that the law says that you have to meet. You have employment posters. They are both federal and state employment posters out there. So if you are 50 or over, it would be the federal poster has to be in your work site. The state one for anybody who is 10 or over has to be displaying the state one. It should be defined in your handbook. And I always like to see some sort of a section that combines FMLA and VPFLA so that it's clear to the employee what they can take it for, who's eligible, what's the process, if I have a qualifying event, who do I go to, and how does it interact with other leaves out there? It's really good to have spelled out in your handbook so that you say VPFLA and FMLA, if you have to offer both, run concurrently. You're specifically saying that in the handbook. And you're specifically saying that it's unpaid leave, but we have ways of paying you during this leave. So for example, it will run concurrently with other kinds of leave, workers' comp leave, sick leave, PTO leave, vacation leave, whatever. It's good to have that out there in your handbook so that it's clear to the employees. Include, so the same thing if you are only offering VPFLA. So if you don't hit that 50-person threshold, you should have a section of it in your handbook. What are the reasons for taking it? Who's eligible, etc. If you're a multi-state lawyer, so you do have other states out there that you need to be following, you may want to think about an addendum to your handbook that deals with that particular state. So for example, in New York, there are dissemination requirements. The state disability and the state parental leave law says that you need to be disseminating this in a handbook if you have it. And you may only have a handful of employees, or you may only have one employee that works in the state of New York. So you can either disseminate that separately to these employees, or you might want to just think about having a New York addendum to your handbook and you plop all of that information in there. So different ways that you can do it. I would say as long as it's in your handbook in some way, shape, or form, you're in good shape. So do we have any questions? I think that pretty much wraps it up. All you needed to know in 55 minutes, right? Does anybody else have any other questions? And I'm just checking the chat. Yep, I see Ellen put that question in there, and I already answered that. Any other questions from anyone? Okay, I think we'll call it.
I have it.
Go ahead.
Can I ask you? Okay. When you say 50 persons, do they have to meet the 30 hours a week threshold?
Okay, it was a little fuzzy and I didn't quite hear you. Can you try it again?
Okay, sorry. When you say 50 persons, do they have to meet the 30-hour-a-week threshold?
For 50 people for FMLA?
Yes.
No, that's a different threshold. One of the earlier slides defines what the threshold is for FMLA.
Okay, we have way more than 50, but most people are very intermittent. So I just wasn't sure if like we have an occasional employee, intermittent employee, if they're over 50, that then they still qualify for FMLA.
Yeah, one of the early slides says how you would determine the 50 threshold for FMLA.
Okay, I'll
So that-
wait till I get that and I'll,
Yeah,
Look for
yeah.
that.
So that should help you to figure that one out.
okay, thank you.
You're welcome. Any other questions before we sign off?
Susan, real quick, this is Rosina. I think she just triggered a question for me. If we meet the threshold, for VPFLA, where we have the 10 to 15 that are 30 or more hours, that means that we follow that. But does that mean that let's say all employees, whether they're 10 hours, 15 hours, they're eligible for that? For
So-
FMLA? It's just for 30 hours or more, right?
Exactly. But it
Okay.
just means that you as an employer have to offer that. It doesn't mean that all your employees are going to qualify, but it means that you fall under that statute. So you're offering it to those who qualify.
Okay, thanks for the clarification.
Okay. Anyone else? Okay. So I will again be sending this out, and I will also send that handout of the state statutes. And the other thing I wanted to mention is I always send out a survey. I would hope that everybody takes a few minutes. It only takes 2 minutes tops to fill it out, but it gives me the feedback that I need to make these presentations really applicable to what it is that you want to hear. This webinar was actually in response to the last survey that I sent out, where I had a couple of people saying they wanted a deeper dive after the Navigating HR webinar into certain topics. So that's why I came up with this one. So please take a few minutes and complete the survey. It's really helpful to me. So thank you, everybody. I really appreciate it, and we'll see you next time.
Thank you.
You're welcome. Bye.